Hello, everybody. Good afternoon, and welcome to our program today, Equality Gained, Equality Lost, the 1965 Immigration Act and its Aftermath. I'm Caroline Fredrickson. I'm the president of the American Constitution Society. And for those of you who may not know ACS, which I hope is very few of you out there, ACS was founded in 2001. We are a national network of lawyers, law students, judges, and policymakers who believe that the law should be a force to improve the lives of all people. And we work for positive change by shaping debate on vitally important legal and constitutional issues, such as the ones we are going to hear discussed today. So I want to first thank the Economic Policy Institute for co-hosting this event today and co-sponsoring today's event. And it's certainly not the first time we have partnered with EPI on programs of mutual interest, and I know that it will not be the last. So in the past couple of years, we have marked the anniversaries of several very important civil rights laws. The Civil Rights Act of 1964, the Voting Rights Act of 1965. But we wanted to make sure that we didn't forget, in the celebration of those other statutes, the Immigration Act of 1965, which was part of this effort to make our laws more fair and more respectful of equality. The 1965 Act dramatically changed the way our nation admitted immigrants, eliminating the national origins quota system that favored Northern and Western Europeans, and opening up our immigration system to those from other parts of the world. Yet despite this laudable goal of ending discrimination in immigration policy, many contend that the act inadvertently led to more discrimination and the divisive immigration policies we see today, and the divisive politics we see today. So to lead us through a discussion with our distinguished panel, we have a real expert, Charles Kamasaki. Charles serves as Senior Cabinet Advisor at the National Council of La Raza, the nation's largest Hispanic civil rights and advocacy organization. Among his other duties, he's been preparing the NCLR network for the implementation of executive action on immigration. He has authored, co-authored, and supervised the preparation of dozens of policy and research reports, journal articles, and editorials, testified frequently at congressional and administrative hearings, coordinated pro bono litigation and legal analysis, and represented NCLR at research and policy conferences and symposia. Since May of 2012, he's been working as a part-time resident fellow at the Migration Policy Institute and is working on a book about the Immigration Reform and Control Act of 1986. So please join me in welcoming Charles.
So hi everybody, thanks to ACS and all of you for coming today for this terrific panel. Thanks also to, and welcome to our C-SPAN audience. Just a word about format. I will begin with some very brief remarks. Each of the panelists will then provide about 8 or 10 minutes of their opening remarks. We'll have a few minutes of discussion among the panel, and then we'll open it up to audience Q&A. In terms of order, following my remarks, Rose Villazor will open with a discussion of the 1965 Act. Deep Gulasekaram will discuss developments since the 1965 Act, and Jayesh Rathod will bat cleanup with a discussion of how the Act and subsequent developments have affected worker rights. I would just note that we're not going to go into detail on each speaker's bio. All of that is available to the audience here at EPI. But before we get to this 1965 Act itself, we might want to start with a brief recap of what came before. So with thanks to my Migration Policy Institute colleague, Muzaffar Chishti, who did a very similar introduction about a month ago for a different event, let me try and give you the history of the pre-1965 U.S. immigration policy in 3 minutes or less. And it's actually not that hard, because for the first 100 years or so of our country, we had essentially no immigration policy, an open-door immigration policy. Beginning in the late 1800s, Congress began establishing what one might call qualitative restrictions on immigrations, not so much limiting the numbers of people who came, but the kinds of people who came. So there were exclusions written into the law for certain kinds of diseases, for so-called paupers, prostitutes, and so forth. Soon thereafter, Congress passed what are now known as the Chinese Exclusion Acts, the titles of which should be self-explanatory, and the government took other steps to essentially bar most Asians from entering the country. In the early 1920s, the U.S. passed its first comprehensive laws, the so-called National Origin Quota Laws. These statutes created an immigration quota for each foreign country based on 2% of the percentage of that population that was already, or that nationality that was already in the U.S. So if, for example, there were, say, hypothetically 1 million people of Irish descent already in the U.S., Ireland was given an annual quota of 2% of that number, or 20,000 people. In other words, Congress wanted to make sure that the future flows of the country resembled exactly those that were already here. In 1952, Congress passed over President Truman's veto the second major comprehensive immigration reform bill in the country. This was the Immigration and Nationality Act, which retained those national origin quotas and also established for the first time priorities for family reunification and employment visas. This has been called by many, I think, the architecture of our current immigration selection system, which remains in one form or another to this day. Which brings us to the 1965 Act. As we consider the 1965 Act, we might think about several key questions. One, which today's panel will attempt to answer, is an historical one. What happened? Why? What have been the Act's principal effects? A second set of questions involves the Act's major implications. How did the Act shape today's migration flows and immigration policy framework? And finally, what lessons can we draw from the 1965 Act that today's policymakers, scholars, and advocates can learn from as we confront major immigration policy choices facing the country in the 21st century? And to begin our discussion, we'll turn to Rose.
Great. Thank you very much, Charles, and thank you to ACS for sponsoring this event. I'm very pleased to be here today. Just to start off the conversation, it's helpful to specify exactly what the 1965 Immigration Act did. And so let me just quote briefly from the statute itself. In 1965, Congress provided that there shall be no discrimination in the race, sex, nationality, place of birth, or place of residence of immigrants who are coming to the United States. So for the first time in 1965, Congress provided that race shall no longer be a factor in the ability of immigrants to come to the United States. As we consider then the historical implications and the lessons that we might learn from the 1965 Act, it's important for us to think at least of two key questions. These are questions and themes that a book that my colleague Jack Chin and I have recently published, so plug for our book, Legislating a New America. And the overall theme of our book is to underscore the ways in which the 1965 legislated essentially a new America today. One theme that we examine in our book, and something that we ought to more broadly think about with the 1965 Immigration Act, is whether we can consider it as a civil rights law. That is, was it effective in terms of a civil rights, a piece of civil rights legislation, or was it the opposite? was it a failure? In thinking about that question, it's important for us to examine the law's intent, right? What exactly did the act intend to do? I read to you the specific statute, the statutory language, but is that consistent with what the framers of the 65 Act actually intended? On the one hand, Jack Chin at UC Davis School of Law has argued for quite some time now that it should be considered a very important piece of civil rights legislation. It was passed in between two different laws, as what was mentioned earlier, the 1964 Civil Rights Act, and then it was followed by the 1965 Voting Rights Act. We know today that many of these laws were instrumental in facilitating equality in many different parts of American society, but they too are not, they were not perfect laws. By contrast, Jack Chin argues that the 1965 Act should be considered to be the most effective of all the civil rights laws that were passed during that period. And here's why: because not only did it abolish race and national origin discrimination within the US borders for purposes of immigration law, but it did open up our borders beyond this norm of non-discrimination beyond our borders by allowing millions of immigrants from Asia, from Latin countries, particularly Mexico, to come to the United States. So from that perspective, we can think of the 1965 Act as a truly effective and important piece of civil rights legislation. But that view is not shared by all. So also in this book, we examine the critical perspectives of the 1965 Act. Dean Kevin Johnson has argued that because the 1965 Immigration Act for the first time imposed limitations on countries, the ability of immigrants from countries in the Western Hemisphere to come to the United States, effectively then, the 1965 restricted the immigration of Mexicans to the United States. Deep Gulasekaram will discuss how that, what is the connection between today's undocumented population with this impact of the 1965 Act with respect to restricting the immigration of people from the Western Hemisphere. There are also other critics of the immigration law of 1965. For example, Bill Ong-Hing has argued that it did nothing for the immigration of people from Africa. Most of the immigrants from Africa, or those of African descent from outside the United States, came here through either the diversity lottery program that was established in 1990, or through the refugee and asylum policy law that was put in place in 1980. Another scholar, Brian Suchak, also from UC Davis, has argued that, in fact, the 1965 Immigration Act continued to impose some type of a national origins quotas by limiting what was then a limited refugee program from those immigrants coming from communist or communist-dominated country or the general area of the Middle East. So in fact, there remained in the law a form of national origins quota. So the legacy of the national origins of the immigration law of 1965 is quite mixed from that perspective. Was it truly effective from a civil rights perspective, or did it in fact put in place ongoing discrimination that has a disparate impact on the basis of race and national origin? The other theme that I would like to highlight here before then turning it over to the other speakers is that the 1965 Act, as what Charles mentioned, is part of a larger family-based immigration system that we can trace to the 1952 Act. But the 1965 actually brought in what was put in stone under the 1952 Act by allowing for unlimited immigration for immediate relatives of U.S. citizens, so the spouses, children, and parents of U.S. citizens, and also allowed U.S. citizens to sponsor their older children, unmarried and married children. It also allowed for lawful permanent residents to petition their spouses and children, and unmarried older children, so sons and daughters. So ultimately then we can see the 1965 Act as promoting one of the core principles of immigration law, and that is family unification. On the other hand, when you look upon closer examination, you can see that the 1965 Act, because of the system that is set in place, in providing for limited quotas for certain family groups, for defining a very narrow version of what is a family, or who counts as family, and also per country limitations imposed. All of these different factors led to, and still continues to lead to, significant delays in the ability of family members to unify together. So from that perspective, we have to think more critically about what exactly did the 1965 Act promote with respect to family unification, and in thinking of how we might go forward and the lessons that we might learn, we need to also consider then how might we rethink this family-based immigration law. So in sum, the legacy is quite mixed from both a historical and contemporary perspective. Thank you.
Before you start, I might just add, Rosa's observation about family immigration is really important. Opponents of the law or critics of the law have argued that by encouraging family-based immigration, that's what led to so-called chain migration, what we call family reunification, that led to the changing demographics of the society. An important historical point about that, though, is that amendment to the law was actually intended to preserve the national origins quotas by limiting immigration to family members. So in the 65 Act, about 3/4, right, of the visas were reserved for family members. The intent of that was actually to restrict immigration to those who already had family members in the U.S. It's just a little point there. Dee, you want to take us into post-65 developments?
Sure. Thank you so much, Charles. Thank you to ACS for the invitation to be here. So Rose points to this central tension in the 1965 Act. It is equality promoting in many ways, but it also has this tension that creates the problem of illegality as we know it today, by creating essentially a disconnect between, on the one hand, need and demand for immigration into the U.S., and on the other, the legal and political restrictions that would curtail immigration from certain countries of very high immigration, for example, Mexico. The Act creates formal equality in the sense that immigration is opened up to countries from all over the world, but that formal equality is juxtaposed against a background inequality of disparate need and geographic historic relationship with the United States. So for example, Mexico for purposes of immigration is treated just like Mozambique, but the demand for immigration from those two countries is obviously very different. So in 1965, we get this arguably equality expanding, but also problematic act that then creates this concept of illegality as we understand it today. And immediately it starts to create political and legal significance at both the state level and the federal level in the United States. And that's really what I want to focus on. So in fact, this sort of central problem that the 1965 Act creates then creates sort of a cascade of problems that political and legal developments attempt to grapple with, but they attempt to grapple with it without addressing that fundamental disconnect at the heart of the 1965 law. And so you see a series of enactments at both the state and federal level that are, perhaps we could say, biting around the edges of the problem, but not really getting to the root of it itself. And so immediately after 1965, or very soon thereafter, you start to see some of the effects at the state level. In 1971, California passes an employer sanctions law. For the first time, it's able to sort of connect the idea of who should be working within California to the concept of illegality that the 1965 Act helped set up. California is in a fairly 1971, yeah. California is in a recession at this point. This law, this employer sanction law that stops employers in California from, or at least penalizes employers in California from hiring unauthorized workers. This goes before the Supreme Court in 1976 in a case called DeCanis versus BICA. And in that case, the court has to grapple with this idea of states really re-entering the sphere of immigration regulation in a way that they had not after 1880. As Charles pointed out, there was significant state regulation of immigration up until 1880, what we might substitute as immigration law, but from 1875 on, it becomes really the federal government dominant in this notion of the regulation of immigration. Post-1965, though, with the creation of the concept of illegality and the creation of significant migration flows, states start to re-enter, and in 1976, this California employer sanctions law goes before the Supreme Court, and the court says, in response to that case, and thinking about it, it says, the power to regulate immigration is unquestionably a federal power. But the court has never held that every state enactment which in any way deals with aliens is a regulation of immigration and is thus preempted per se. And so the court ends up upholding this law, and this again starts to set up a series of political concerns that trigger both state and federal action later. Several other states joined California. 11 states actually joined California in this form of employer sanctions law, which ultimately in 1986, with the Immigration Reform and Control Act, become preempted by federal law. But in 1986, you see the federal government again attempting to deal with the fundamental problems created by 1965 by setting up a mass legalization program. So one of the first mass legalization programs that the United States has had, but perhaps Charles can shed more light on that, providing the possibility of the undocumented population at that time, or significant portions of the undocumented population at that time, to legalize. It's an attempt to, at least at that time, I think, conceived of as a one-time fix to this problem of illegality created by 1965. But it becomes very clear within the next few years, by 1990, that that one-time fix has not worked. The undocumented population of the United States continues to grow. So 1990 and 1996, the federal government attempts a more punitive response to that same problem. And so 1990 and 1996 federal enactments attempt to enforce the United States out of this problem of illegality by setting up significantly harsher deportation standards, and through law creating a larger class of people who might now be subject to deportation. But as it turns out, you can't enforce your way out of the problem either. And so 1996 in many ways amplifies the problem of illegality created by the 1965 law at its inception. 1996 also does something that's less recognized but also extremely interesting. It provides in the law several provisions that allow for state-level enactments with regards to the control of immigration, or at least the regulating the lives of immigrants. Many of those provisions actually, although enacted in 1996, lie fallow for the next several years. As we argue as my co-author and I argue in our new book, The New Immigration Federalism, that what ends up happening is in the last 10 to 15 years, those provisions of the 1996 law that allow for significant state and local involvement become activated through political mechanisms, and you start to see what we've witnessed in the last 10 years of immigration lawmaking. That is, no federal law, but significant state and local enactments, both on the restrictionist side, but more recently trend towards the integrationist side, that attempt to deal with, again, this fundamental problem of illegality, now which has grown to roughly 11 million people in the country who are unlawfully present as defined by the INA. The current landscape, and this goes to the theme of our discussion here today with regards to whether the 1960, or how we should think about the 1965 Act in terms of equality. We currently have a patchwork of laws across the United States in which state and local laws are affecting the lives of immigrants in significant ways, where the prospects for somebody who's illegal or undocumented in the United States vary drastically. So for example, somebody in California has significantly different prospects than somebody who might just be 50 to 100 miles away in Arizona, for example. It's a form of structural equality that we might want to think about as we move forward. How should we think about this extreme variation of laws in the United States that in many ways are the laws that impact the lives of immigrants on a daily basis? Second, we have sort of an internal question of equality with regards to how we should think about integrationist laws in places like California, which have, I think California as a state is probably a leader in the way in which it's thinking about and treating both immigrants generally, but undocumented immigrants specifically, and cities like New York City, which I think at the local or city level is also a significant integrationist platform. Versus restrictionist laws in places like Alabama, Arizona, cities that are interested in significant immigration enforcement. Should we think of these two different types of laws as similar for purposes of our judicial understanding and discourse around whether we only require one immigration law at the national level or whether we should allow these various sorts of state and local efforts? And then finally, a question of thinking about how this landscape has developed, where federal law is creating the conditions of that essentially create 11 million unlawfully present persons, but we have significant state and local responses to this federal law. To what extent should we allow these state and local enactments to act as our form of de facto national immigration policy? One of the reasons this has become significant, as our research suggests, is that state and local efforts, once they become entrenched, affect national lawmaking. It becomes quite difficult for federal lawmakers in Congress from those jurisdictions to vote in ways that would override those local preferences. So for example, John McCain, who used to be, if you look at early 2000s, even late 90s, immigration policy, was what I think most people would describe as a moderate on immigration reform, would have even promoted and did promote certain acts that we think of as part of a comprehensive package, including legalization programs. But after SB 1070, after Arizona's Proposition 200, after Arizona's Arizona Workers Act, he no longer can hold those positions of moderate immigration positions in the federal Congress, and is forced to take more extreme positions and more restrictive positions, I should say, more enforcement-minded positions, and you really see sort of that middle disappear. So I think, to get back to the theme, and I'll sum up by saying that the legacy, or one of the legacies of the 1965 Act, is the creation of this concept of illegality. Because our major federal enactments since then have actually not dealt with that fundamental problem, what we've seen is a significant number of state and local enactments and also federal enactments that are attempting to chip away at the problem, address the symptoms of the problem without getting to the root of it, and now it's led to a situation that I would argue in 2015, in which prospects, at least in the near term, for significant comprehensive reform to that 1965 Act have become extremely difficult.
Jayesh?
Thank you, Charles, again for moderating, and also I want to thank both ACS and EPI for hosting this event. I'm pleased to be here. I'm going to build upon some of the remarks of my fellow panelists and talk specifically about the impact of the 1965 law on the workplace in the United States and the landscape of workers' rights. And when Lyndon Johnson signed the law into act, he said, "This is not meant to be a revolutionary bill," right? And that quote is often tossed around, and I think when we look at how the law has transformed the landscape of the U.S. labor market, I think we can only say that it has in fact been transformative and revolutionary in some positive ways and also in some very negative ways. And as some of the other panelists have mentioned, the 1965 law is credited for creating the sizable undocumented population that we have in place today. Now keep in mind that before 1965, there were no numerical quotas on immigration from Latin America. And of course, for centuries, right, there's been a significant economic interdependence between the territory that we now know as Mexico and the United States. But with the 1965 law, we see the imposition of a quota of 120,000 visas from the Western Hemisphere. And of those, initially only 40,000, Mexico was set at a 40,000 limit, and then by 1977, it was cut down to 20,000 visas from Mexico. Now, as Deep alluded to, this raises an interesting question around formal equality versus equity, right? And this is a critique that we can make generally of the companion civil rights legislation that was enacted in the 1960s. certainly it did create formal equality, but did it in fact create the equity that the legislators were looking for? And one might say certainly in the immigration context that it hasn't created that equity, given the unique relationship that the United States has with Mexico. But to understand how specifically that this law generated the growth of an undocumented population, we need to understand what was happening historically in the United States at that time with the foreign-born workers and the labor market. And as many of you know, beginning in 1942, the United States and Mexico had entered into a bilateral treaty, essentially, which allowed for foreign workers to come work temporarily, Mexican workers to come temporarily work in the United States. This is known as the Bracero program. And the program allowed a total of about 5 million workers between 1942 and 1964 to come to the United States to work temporarily. And the Bracero program fueled the agricultural sector. It also fueled some industrial work as well. It obviously played a significant role in the US labor market, and initially, of course, was positioned as a replacement labor supply given the shortage of workers during World War II, but eventually became an important feature of the US economy. The Bracero program ends in 1964. 10 months later, 1965 immigration law is enacted. There we have, of course, hundreds of thousands of Mexican workers who had been participating in the Bracero program with no real pathway then to integrate permanently into the US labor market, right? And so this is one of the factors that's contributing to the growth of the undocumented population, right? And at the same time, we have employers who are continuing to rely on that labor supply and are therefore turning to undocumented labor. Now, there's some interesting historical literature around this, whether was it all nefarious in terms of the exclusion of Mexican workers. Certainly, some part of it was intentional. There was a significant lobby at the time that was pushing for the exclusion of Latin American workers or Latin American visas with the concern that they may overtake the US population. There's other literature that's interestingly notes that what was happening in the agricultural sector at this time was mechanization, right? That there was a feeling that, well, maybe we actually don't need all these workers because technology is going to save us, right, in terms of harvesting cotton and tomatoes. But of course, that didn't fully bear out in the years that followed. So the end of the Bracero program is one significant impact, and then also what we see at the same time is that there was not only was there a cap on the number of visas that were available to Mexican nationals, right? But we also see a shift in the temporary worker programs. So at this time, there had been, prior to 1965, a temporary worker program, the H-2 program. It was relatively small in scale. It still continues to be relatively small in scale. But prior to 1965, the burden was on the government to show that the workers that were coming in under the temporary programs would not harm the US workforce. But beginning in 1965, that burden then shifted to employers. So what this meant is that there was a more of an active ex-ante screening role that the government played in determining which temporary workers and generally which foreign-born workers would be able to come into the United States. And this also gave the government more control in terms of limiting the access of Mexican and other Latin American workers into the US labor market. I'll also note that, of course, during this time, we see the United Farm Workers coming out specifically taking the position that undocumented workers should not be in the agricultural sector, again, which kind of set the relationship between undocumented workers and immigrant workers generally and the labor market for many years that would follow. So what is the larger consequence of this today, of these kind of historical developments? I would argue that there's a few of them. One, of course, is that by not creating a permanent pathway for these hundreds of thousands of Mexican workers, it's kind of labeled the Mexican workforce at that time and arguably today with a type of permanent transience. The idea that they aren't able to be formally and permanently integrated into the US labor market. And some scholars have argued that in some respects, the 1965 law replaced the Asian immigrants with Latino immigrants as the kind of outsider, right? Whereas Asian exclusion was in place during the national origin quota system up through 1965, and that was eliminated, and that was a good thing. But there was then de facto exclusion of Mexican and other Latin American nationals and kind of creating this kind of permanent outsider class that could be demonized and exploited. Now, so we have all these factors building up, right? The significant economic interdependence of the regions, then we have the end of the Bracero program, the change in this labor certification process, which I alluded to, and the inevitable result is the growth of a huge, vulnerable, and exploitable, undocumented population in the United States, which we continue to see today. Now, what is the impact of this population? Of course, we see it in the experiences of foreign-born workers in the US labor market, both documented and undocumented. Certainly undocumented workers now are experiencing disproportionate levels of wage theft, other forms of workplace discrimination. Their experiences with workplace injuries and fatalities are disproportionate to the representation in the US labor market, and the list goes on. So building on top of that, of course, is then we have a culture of immigration enforcement, which has been fueled by the growth of the undocumented population, which of course is also affecting the experience of workers in the workplace. So I know I've been sounding like there's a lot of gloom and doom about the 1965 law, but there are of course positive things, right? So Charles mentioned that of the entire visa allocation under the 1965 law, 74% were allocated to family-based immigrants, right? Only 20% went to employment-based. Now, some might say that this was the root of a major structural problem in US immigration law, 20% in 1965. Yeah, so that as of the way the visa allocations were laid out in that law, 10% went to members of the professions or workers with exceptional ability, and another 10% went to those who are performing skilled or unskilled labor. And some might say, well, as an overall allocation, that's relatively low, right? And that the balance wasn't the right balance. And there's a larger critique around the US immigration law and whether or not we're doing what we need to do to actively attract the best talent in the United States. And we can have a conversation about that. But there was an impact, right? We did see, despite that relatively small allocation, a significant growth in high-skilled immigration in the late 60s and early 70s. And many of these immigrants from Asia and elsewhere have made a significant impact on the economy. So we could say, well, was this the right allocation? That's a good question. You could also note the positive contributions. You can also note the particularly inclined nature of immigrants towards self-employment and how that's affected U.S. business markets. On the flip side, we could reflect on how these employment-based categories have caused economic difficulties or a brain drain in countries of origin. That's another aspect to look at. Just two more points and then I'll wrap up. The first is the impact of the 1965 law on African Americans. And I think this is something that gets relatively little attention but deserves more attention. The law was part of civil rights legislation. And we often talk about the impact on Asian Americans or Latinos, but I think it's worth reflecting what the law has meant for African Americans. And of course, there's a very vigorous debate about whether or not immigrants and immigration generally is positive or harmful for African Americans. And there's a recent study put out 2 years ago that showed that, in fact, there is a positive impact. For example, those municipalities that attract immigrants tend to be more positive in terms of the economic impact overall, including for African Americans on wages and income. There are, of course, other general studies that show that, including EPI, that's done some great work around the wage impact of immigrants and showing that there's a small but positive impact. At the same time, we can also look at particular industries where employers have intentionally chosen to replace traditionally vulnerable groups such as African American workers or long-standing Latino communities with guest workers, right? And that is purposefully in some instances because those guest workers are more exploitable and vulnerable. So I think that's something that is worthy of some more broader consideration, but I think it's also helpful to think about this in terms of a broader frame of civil rights and equity. So when we look at the vulnerability of the Latino immigrant community and the ways in which both the undocumented population and the corresponding enforcement efforts have affected Latino communities, fueling a type of racial profiling and racial discrimination in some instances. I think we have to ask ourselves, what is the impact of that on other communities of color, right? Is it nurturing a type of anti-minority attitude that is going to be harmful to African Americans? Another way to look at it, we now have, of course, a large undocumented population, which has then spurred the growth of a large enforcement apparatus, including the Immigration Reform and Control Act, which has been mentioned. That reform apparatus and the enforcement has then pushed some employers to move away from undocumented workers and rely more on guest workers or prison labor, for example, right? Or other types of workers who are more maybe lawfully working but more legally controlled. And so I think we need to think about, perhaps in even subtle ways, the ways in which that type of series of events is now impacting the experience of African American communities. And the final thing that I'll say is just relating to the, in some ways, just the indeterminacy of all this. You know, we of course know that there's been a significant growth in the undocumented population. We know that you could look at family-based, but you know, the interplay between these things is very complicated in immigration law. So you have people who come in as family-based immigrants, but then of course make incredible economic impact. Then you have people who come in under the employment-based scheme, right, as entrepreneurs, but then they'll bring in family members, right? So it's difficult to cabin in a very isolated way the specific economic impact that workers have had. But I think it's fair to say that as we look forward, there still continues to be a significant deficit in pathways for temporary migration, for economic migration. That's a major flaw in the U.S. immigration system. There were some attempts to remedy that in 2013, but there still is a long way for us to go.
Oh, good stuff. So thank you, Jayesh. It strikes me that in addition to this equity versus equality frame, I think one of the lessons of the 65 Act also has to do with supply and demand. That is to say, pre-1965, about 80% of all immigrants came from Europe. Post-65, that was exactly reversed. Many people point to the supply side, as it were, the how we changed our visa systems for that explanation. Surely that is at least partially true. But it strikes me that very few people talk about how much demand was there in a booming Western European economy, and also Eastern Europe, which was largely behind the Iron Curtain that did not permit emigration. Was this really a question of what we did on the supply side, or was it really more of a question of what happened with respect to demand for visas from other countries? At this point, I guess I'm curious about what the panelists might have thoughts about with respect to each other's presentation. So without necessarily going in detail, but or in order, let me start with Rose, whether you have additional comments.
Well, I wanted to respond to what Jayesh said about the gloom and doom. It's true, we're here being very critical of the act, but one of the things that we have yet to mention is how the 1965 Act relates to the overall population today and where we will be in 2043, at least as predicted by demographers. Right, so by 2043, the prediction is that the United States will no longer be a majority white population, white country. If anything, it would be the opposite of that. And that is that there will not be a single, quote, race that would dominate the U.S. population. Instead, different pockets of minority groups will then emerge as one of many different populations in the United States. And we can trace that demographic change to the 1965 Act because of the immigration of many immigrants of color, particularly from Mexico, China, India, Philippines, and the Dominican Republic. Those are the top sending countries to date in the last several years. So it's one way to examine those numbers is to think of it from the perspective of what would have happened if Congress has never imposed any kind of racial restriction on immigration. Will we be would we be in a different place today? And if so, how differently would our population look like? So one argument would be that the 1965 Act can be thought of as sort of essentially erasing, right, the effects, or both intentional and the effects of those racial barriers to immigration law. So from just invoking from affirmative action theory, it's a way to address the ongoing impacts of formal discrimination. So that's from one perspective, we can think of the 1965 Act as a positive, from a positive perspective, because it's promoting this normative view of non-discrimination and erasing the effects of past discrimination. Others might say that that's actually a negative perspective, right? We don't want to promote diversity in that way. That it's one thing to think about allowing everyone to have equal access to the United States for purposes of immigration, but it's another to think about immigration law as a means for diversifying the immigrant stream. So I wanted to put that in there as a way to also consider the role that the 65 Act played in our current population and forthcoming population.
Sure. So I'll say a couple things. First, I think Jayesh's point about taking us back to the Bracero program is one worth re-emphasizing, only because in the 22 years directly preceding the 1965, you had a set form of cyclical migration between the United States and Mexico, and there are certainly significant concerns with programs like the Bracero program. Lots of ways in which choice and agency might have been coerced with regards to those workers. On the other hand, it was a way of promoting a cyclical and seasonal form of migration that in its time processed over 2 million immigrants in its 22 years of existence. Even in the last couple of years, processing over 200,000 Mexican workers per year into the United States. And so to bring that to an abrupt close 10 months after that program ends is going to have significant effects, because people simply don't respond in that way when they have ties in the United States. Employers don't respond that way when they depend on that labor and have become used to that labor in the United States. The other thing I'll say is I think it's interesting to think about what Rose just mentioned about the demographic changes in the United States in the coming years and very soon in the coming decades, significantly shifting what we think of as minority and majority populations. I wonder, and this is an agnostic open question, I wonder to what extent without significant federal immigration reform, or at least rethinking ideas of illegality, whether even as those demographic changes happen, our concept of illegality necessarily changes. And so if we think about prior, by the late 1800s, illegality essentially, as Charles pointed out, meant Asian. It meant this nefarious, unassimilable group of people from Asia who were coming to take jobs, apply opium in the United States, and generally debauch the morals of the United States through Asian prostitution, for example. Right. So 1875, the Page Act is really directed towards this problem of Chinese prostitution coming into the United States and debauching the morals of places like San Francisco and its surrounding areas. But I wonder, even as now we know we don't necessarily, although, for example, when you think about Jeb Bush's campaign rhetoric, right, he says, when I was thinking about birth tourism, I wasn't talking about Latinos, I was talking about Asians. Somehow that made it better in his mind. But I do think, obviously, in 2015, as a general matter, we've replaced that group towards which we have this animus with regards to immigration. And the way in which we now think about the Latino population is in some sense an immigration question, even though that doesn't actually track the demographics of that population, significant numbers of citizens with long histories in the United States. But we label them as illegal operating, I think, as a very thin veneer for race and racial restriction. So again, an open question as to, even as our demography changes, to what extent does our concept of illegality change without significant changes at the federal level?
And that last point is a very interesting question. Just a couple of reflections. I think when we think about the demographic diversification of the U.S., and I definitely think of that as a positive, I think, but the particular pathways in which, for example, Asian immigrants have come to the United States post-1965 have certainly created some complications in terms of how the groups are racialized and how they're positioned in terms of the class positioning within the United States around the model minority myth. I think this is something, my father was a beneficiary of the 1965 immigration law. He was able to come to the United States because of that law. And I think as a consequence, many Asian Americans are then positioned as affluent, successful, high achieving, etc. And while that's certainly true for some portion of the population, I think it's then created a lack of a complex understanding of the real diversity, economic and otherwise, within the Asian American community. I think the same might be said about Latinos. And also I think African immigration is such a fascinating phenomenon. There was some reference to this, and it really didn't come about so much as a result of the 65 law, but some of the subsequent enactments. And the same might be said about, and I'm certainly not an expert on this, but have done some thinking about the interrelationship between the African American community and more recent waves of African immigrants and access to opportunities and what that means, right? How do we define African American in an era of growing African immigration to the United States, and kind of the interrelationship between the historically present African American community and African immigrants in terms of their access to different kinds of opportunities. It's a fascinating question, I think, that we can think about. And I think, Deep's comments and others just emphasize the political complexity, both at the federal and state level, and just all the different types of coalitions and interests that are at play in immigration reform. Now when we look at it, it sometimes feels hopeless, right, to see all these different strands of interest that are trying to be aligned. But I think what the kind of Deep's work and others emphasize is that the historical record shows us that it's always been this complicated. There's lots of interests that have been at play in terms of crafting immigration policy, certainly with respect to the workplace issues. And there's been a particular uncertainty about how to deal with immigration from the Western Hemisphere. What I was talking about and what others have talked about, the cap on Western Hemisphere immigrants, it wasn't a done deal, right, from the beginning. It was just something that was a result of intense negotiations in the months and years preceding the 1965 law, and that's where the negotiations landed. But it's still, if you read the law, there's, in addition to putting in a cap, they also called for the creation of a select commission on Western Hemisphere immigration. I think we still need that today, in light of what's happening in Central America. But just a deep uncertainty, I think part fueled by racial concerns, economic concerns, about what to make of this long-standing historic relationship between the United States and the rest of the hemisphere. And I think that has always been politicized. It still is extremely politicized, but it remains our greatest challenge.
So are there lessons? We've been mainly retrospective, as is appropriate, looking back and commemorating a 50th anniversary of a major reform law. Are there lessons we should take from that, from the last 50 years, and apply them today? So for scholars, legislators, advocates, if we could maybe identify one thing we think is most meaningful from this history that is applicable to current contemporary debates.
Well, I'd like to focus on family. Who counts as family for purposes of immigration law? so there are different ways of thinking about how we might restructure the family-based immigration program that we have. In fact, the last the bill that passed the Senate, the one that many had hoped to become law, had different ways of thinking of family-based. They would have cut off the ability of U.S. citizens. The bill would have cut off the ability of U.S. citizens to petition for their parents, to petition some of their older children who are married. If they reach 31 years old, then they will no longer be eligible for immigration to the United States. So, and on the other hand, that bill would have also allowed for lawful permanent residents to bring in their spouses and children. So, in terms of lessons and how the 1965 Act, building upon the 1952 Act, redefined the meaning of family, it's important for us to think about whether we might want to expand our understanding of the family. There are other countries that allow for grandparents to immigrate, for other close family members to immigrate. So one way would be to think about broadening the meaning of the family, or we might consider narrowing the meaning of the family, right? Just limited to spouses and children, young children defined as by the statute as 21 years and below. So those are, because the way that our family-based immigration program right now is structured, that leads to, on the one hand, increased family unification, but on the other hand, extremely long delays and separation, then there's something wrong with the system, right? And so it's important to rethink how we define the family.
So I think if you think, so the question, one way of thinking about that question is, what's the best immigration policy for the next 50 years, right? Or if we were doing this in 2065, what would we say, or what would we look back and say? I think one of the things that, if we're going to do that, we have to ask what exactly is our goal, right? What are we trying to accomplish with any form of immigration reform? You might ask the question from the labor perspective and say our goal is to maximize the economic output of the United States and to be functioning at an efficient level. Perhaps that's one goal we might pursue, and significant portions, constituencies with the United States are want to pursue that goal. But there's also a significant portion of the United States that's committed to this goal of the purpose of immigration law should be to not have illegal immigration. And that's a more difficult and complex question to address, because one way of addressing that would be to say, okay, well then, if the law doesn't create illegality, you won't have illegal immigration or unauthorized immigration. So it's possible if you start from that premise, it's not clear which of two paths you can take. You could say, well, that means that we should then simply match our immigration in the United States based on demand, and if availability matches demand, then it's likely that you could get down to or at least a manageable number of unauthorized migrants. But if what you take from the last 50 years is that we should have greater enforcement as a way of reducing that 11 million number, then your immigration policy is going to look significantly different than it is today. In fact, it's going to require an enforcement apparatus that is exponentially bigger than the enforcement apparatus that we have today. And so one of the lessons perhaps we might take from the last 50 years is that regularized or cyclical mass legalizations are likely not going to be the way of reducing the unlawful population to zero. But also, it's very clear that mass enforcement and the ratcheting up of an enforcement mechanism is also not going to reduce that number to zero, which leaves sort of this last choice of really thinking hard about how demand matches availability in some meaningful way. Again, sort of what I would argue, or what Rose has pointed out, is one of the root concerns of the 1965 Act. And so I think these are some questions that we might want to think about, including what's the goal? What are we trying to accomplish with this immigration law going forward?
Yeah, I'll be brief. I mentioned this earlier, and of course I'm looking at these questions often from a kind of a labor or economic angle, and the historical record, in my view, is very clear that historically, certainly since 1965, there simply have not been enough pathways for legal immigration into the United States for people interested in coming for economic purposes, whether that's coming for unskilled work, semi-skilled work, high-skilled work, or small level entrepreneurship. There just simply aren't enough visas available, whether you're talking about temporary visas or permanent visas. And I think that's a fundamental flaw in the system, and one that has created a range of pathologies relating to immigration enforcement, economic problems kind of locally and otherwise, and I think that's something that needs attention. And the, excuse me, the 2013 bill in the Senate went significant ways towards remedying that by creating a new non-immigrant visa category that would allow larger numbers of foreign workers to come to the United States to work temporarily. Those workers wouldn't have to be beholden to a specific employer. There was some degree of visa portability, which is another feature that needs to be introduced into the employment-based immigration system. So I think that's a tension that just needs to be worked out. It is very complicated because there's a lot of different imperatives when we talk about foreign-born workers. We're talking about attracting talent, we're talking about boosting the economy, but we're also talking about protecting US workers, right? And often these are at odds with one another, to be candid. So not always, right, but there are ways to reconcile these different interests, but that, I think, is the larger project that needs to be undertaken.
Thank you. Unless you all have anything else to add, you're free to jump in on. Now is the time for audience Q&A. We have a mic. Please wait for the mic to get to you, and then please identify yourself before asking the question.
Yeah, thanks. Sorry, I know I've kind of been jumping out of my seat here. I'm Peggy Orchowski, and I'm a congressional correspondent for the Hispanic Outlook, and I've been covering immigration for the last 10 years, and I just wrote a book called The Law That Changed the Face of America, and I'm just really pleased with this panel because you talk a lot about some of the stuff I struggled with. I'm glad that Deep corrected you in that there, even though there wasn't national law before '86, there was, of course, the states and localities. I mean, if you were Jewish, forget going to Boston, you know. And there was a lot of ways cities and states regulated immigration. And I'm glad Jay corrected you, Pratt, that Mexicans were not included in the quota of 1920s. And I'm really glad you talked about family unification. I mean, I think what you haven't spoken about are the drivers of immigration and how they change the demand. So, like, for instance, technology. You know, with Skype, do we really need family unification now? You can, you know, talk to your mother-in-law every day if you want. Does especially things like the nationality quota. This is a thing. You didn't talk about the 7% rule. The thing was that in 1965, the 1964 law prohibited national origin as one of the civil rights. You cannot discriminate on national origin. Every nationality had to be treated equally. And discrimination also means preference. It doesn't mean just discriminate against, it means preference for. So you can't say, well, now we're not going to have preference for Northern Europeans, but we're going to prefer all the Mexicans. I mean, how do you do that every nationality is treated equally? So they put a 7% law that no nation could have more than 7% of all the green cards given out. That still exists today. I don't think a lot of congressmen know that. So Mexico doesn't get any more than 7%. If Iceland doesn't use 7%, that number goes into the amount. But nowadays, in terms of globalization, and this is getting my question because it's something I've been really struggling with, does it really matter anymore that we give a preference or not to national quota? And globalization, I mean, we're seeing how high-tech workers, a lot of them are from single countries, China, India. You know, are we really going to say we're going to do the 7% rule on that? If we legalize most of the illegal, especially dreamers, a vast majority are Mexican. Doesn't that give a huge advantage to Mexicans? Come in illegally and then get an amnesty? I mean, that's kind of preferring Mexicans. So is that civil rights? Is it the executive orders for DACA going to go against the civil right of giving a national preference? So is that even important anymore, that part of civil rights? And then the last thing that I've really been struggling with is, and you guys, this is the question you guys can really answer. immigration's not a civil right, but I think that the 1965 Act and all the fervor about immigration, and I used to see Kennedy pounding the table and saying, immigration is the next civil right in our nation, and it isn't. So I'd love you to address that.
Thank you.
I mean, there's a lot in that. I think honestly, your question boils down to immigration. Go. No. I'll let a few thoughts. So, the questions of how we should think about things like Dreamers, DACA, DAPA. The questions of that, I mean, are partly influenced again by 1965 because those questions may not come up at all if immigration law is fundamentally structured in a different way. But it also suggests, so your question sort of suggests, once you have, should we, in a sense, reward a particular population for legal transgressions of entering unlawfully or having been unlawfully present, and to what extent does that fit into a civil rights narrative? And I'm not sure there's a great response to that, except to say I think your perspective on that depends on how you view the law and illegality. Now, if you think about illegality as something preordained, as sort of a priori, there is this concept of illegality, and once you cross that threshold, there's no way of rectifying it except through violations of what we might fundamentally think of as rule of law, priorities and equality norms, then that's, I'm not sure there's a lot that I can say here that's going to change your mind about that. But if you think of, I think, if you think of that, the creation of those populations, for example, a dreamer population, as a result of a functional, this is how functionally law works on the ground when you have significantly harsher congressional penalties against the historical backdrop that Jayesh beautifully laid out for us, then it suggests that initial transgression, or what we might think of as that transgression of unlawfulness or illegality, really isn't the ending point of our discussion. That the real question then is, how should we as a populace then think about that population? How should we direct enforcement efforts towards that population? To what extent does it make sense to enforce law against that population? And if that's our starting point, then I think we have a very different orientation towards the rights and civil rights of those sorts of groups. I do think that one important lesson, going back to the question that Charles asked about 1965 and Rosa's comments, was that the 1965 Immigration Act occurred against this backdrop of significant civil rights advancement in the United States, including the Civil Rights Act of 1964 and the Voting Rights Act of 1965, 10 years on the heels also of Brown versus Board of Education and a revolution in equal protection jurisprudence in American courts. So what's the lesson that we can draw from it? I think one lesson is that the immigration law for the future and our current push for example, comprehensive immigration reform should also take that frame of a civil rights, as a civil rights legislation. This is, I think, the civil rights project of our time, and will continue to be as long as we don't as long as we avoid addressing this problem of illicitness and illegality.
Just a word or two just to build on that, and I think Deep has really nicely framed this question of legality, which I think it really does shape how one looks at this. And I think that really is the key frame that one has to grapple with. But in terms of, is it fair to call immigrants or immigration law as a civil rights issue? I would argue that absolutely, in light of kind of the types of mechanisms that have been deployed by the state against foreign-born persons, there are very clear parallels between the experience of African Americans, Latinos, and other historically disadvantaged groups, and the experience of foreign-born persons. Now, I'm not equating the experiences, nor am I saying the legal frameworks are equivalent, but if we look at practices like racial profiling or mass incarceration, the same experiences that African Americans and others had experienced are now being replicated in some respects on foreign-born persons, especially Latinos. And that is more than just a rhetorical connection. There's some a deeper connection in some ways that I think is worth exploring. And I think, so that's in part, I think, what is fueling this. It's the next civil rights movement.
Maybe that happened 50 years ago, but I think now, especially with millennials and the diversity.
Can you wait for a mic, please?
I think we're changing that whole idea. Racial profile, with racial profiling, somebody, I mean, it's not a race, but I'm Latino. And they're so mixed now.
I mean, the huge diversity of Latinos, and I love the millennials. I call them the whatever millennials. They're everything, you know, Peruvian, Chinese, Mormons. My best friend, you know, they're everything. How do you racially profile in this incredibly? I mean, this is a question of affirmative action people are talking about now too. So I'm not sure that dynamic of the '60s. It does. I think in some ways we're more like the 1920s now than we are the 1960s, with huge income inequality, a fear of war, fear of a foreign invasion, tremendous difference in working conditions. And that was what drove a law that people wanted more border control, not less. I think we're headed more for that in the public. That's what Trump is touching on. There's not a big civil rights movement like in the 60s that's driving a more liberal law. That's how I feel.
Thank you for that.
No, let's just.
Okay, next question.
Hi, so I'm Ross Eisenbray from the Economic Policy Institute, and I have a question because I'm very confused about pre-65, the ability or the status of people who came without authorization. I mean, people were deported, I know, and for all kinds of reasons, and it seems that being here without authorization would have been one of those reasons. And then I just want to make a comment about family and one of the new civil rights, which is how we treat LGBT people. This law, I think, allowed or required the exclusion of homosexuals. I'm not sure, but that was certainly what happened. And going forward, one would hope that that wouldn't be the case, and that a new way of looking at family, even for immigration purposes, would take into account LGBT families.
Yeah, so let me comment on that last point about the exclusion of gays and lesbians from immigration law. That it's true. 1965 kept that in place. In fact, the law classified people who are LGBTQ as having some kind of a medical condition that then led to their bar from immigration law. And it was not until 1990 that Congress lifted that exclusion. So it's still fairly recent in our memory. And as a result of the Supreme Court cases that invalidated DOMA, and then also and both provisions of DOMA, now LGBTQ families are able to bring in their family members here to the United States. So it is catching up. That part of our population is now finally able to have that benefit in immigration law. And so it's unclear to me right now, for purposes of family, what might be, in terms of civil rights, how we might be able to redefine family from a civil rights perspective, other than to think about the family structures that we currently have in place today, who are, with respect to speaking of the 11 million undocumented immigrants, I think it's important for us to examine how are the families on the ground, the lived experiences of families, who do they count as people who are special to them? And should they benefit from comprehensive immigration reform and a reformatting of our family-based immigration?
Want to take the unauthorized, Ross's first question about the status of unauthorized people prior to?
I mean, I'll take a shot. I mean, I think one perspective, I think that's a great question and an important thing to point out. Certainly, if you look at, obviously, even in the late 1800s, soon after the first provisions of the Chinese Exclusion Act, came provisions that were intended to make as a default proposition the presence of people of Asian descent in the United States immediately deportable, provisions which were upheld by the Supreme Court. When we get to the early 1900s, as you suggest, there was significant mass deportations in the United States. So it was not uncommon, for example, especially late 1920s, early 1930s, Los Angeles, to see roundups of Mexicans put on trains back into Mexico. And so that is certainly true and certainly did exist. That the enforcement at that time, though, at least my understanding, it was that one, it was haphazard, right? Looked a lot like if you looked at the early 2000s workplace enforcement by the Bush administration, which was high profile, intended to cause a lot of publicity when ICE agents entered, for example, a meat packing plant. But in terms of actual effect on the broader population, obviously it creates fear and chills certain sorts of behavior, but it was not a systematized form of enforcement. And very similarly, I would argue the 1930s, for example, roundups and mass deportations operating that way, one, haphazard, two, non-systematized. But also the scale of who we're talking about as the unauthorized population, as the population that could be targeted and removed, was simply not the scale that we have today. Right? We don't think about it in that way, and there was still fairly relatively open movement across the border. So as an example, when the Bracero program was operating in post-1942, Texas was actually initially excluded as a state that could take braceros, mostly because of the significant discriminatory actions that were happening in the state of Texas against Mexican workers, and the Mexican government simply refused to allow Texas initially to participate in the bracero program. So Texas then simply asked the border agents at the Texas-Mexico border to allow free migration of people outside the bracero program into Texas so that they could then use them as laborers, and that system continued for a significant amount of time. But certainly they were illegal or unauthorized in the way that we would think about them today, but not necessarily subject to the mass deportations or the idea of enforcement that we would understand today. And so I think it's an excellent point, but I still do think that 1965 really changes both the scope, volume, and quality of the nature of illegality. Another thing I'll end with this note is to point out that up until 1990, there were literally 3 crimes that could get you deported, that made one deportable from the United States: murder, rape, and I forgot what the other one was. But 1990 is when the United States Code starts to exponentially expand the number of crimes that can get you deported. By 1996, which is the law that we have today, if you look at the part of the code that defines aggravated felonies, 101A43 of the INA, it now goes on for several pages. And these are embezzlement, fraud, just continues, drug offenses, all of them get counted. And so you fundamentally change the group against which that enforcement can be directed.
So, Ross, let me just add one other thing, and I think it really goes to Rosa's initial point about, in some ways, where you stand on these issues depends on where you sit. The history, your perspective is really shaped by history. So, from a sort of Latino civil rights perspective, when asked, what about the unauthorized prior to 1965, one might answer, first, it wasn't a large-scale problem, in part because we didn't enforce the law against Europeans. So the vast majority of European immigrants who came legally the old phrase was, you came with a tag on. That is to say, someone paid for your passage, usually an employer, from Italy, say, to Ellis Island. That was actually technically illegal because, according to the U.S. law at that time, we did not permit indentured servitude, and yet, some would argue, even the majority of people who came to Ellis Island came technically illegally. Second, until I believe it was until the 1952 Act, there was an automatic statute of limitations, so that anybody who came unauthorized, again, mainly European, automatically was able to legalize without any action as long as they evaded detection from the law, which as Pete has noted, was not very significant. And third, to the extent there was major enforcement, it was through these repatriation campaigns, which I would argue were highly racialized. And there was not one of them, or there were actually 4 of them, including so-called Operation Wetback in the 1950s, where millions of Mexicans and other Latin Americans were deported, largely without due process. And that included, millions probably of U.S. citizens as well. So when you ask who are the unauthorized and how did enforcement take place in those days, I don't think one can fairly answer that with a simple answer. It depended on who you were, where you came from, and how one might have come to the attention of people. So sorry for that speech, but I thought I would add that. Next question.
Thank you. My name is Bob Remuson. I am a practicing immigration lawyer for the last 40 years or so. And what strikes me in some of the things you people have been saying is to remember that I think historically both European immigration and also Mexican immigration, people came and went freely. And therefore the concept of being here illegally wasn't as salient because you came here, you worked for a while, maybe you worked for a year, maybe you worked for 2 years, maybe you worked for 6 months, you went back to your family with the money you had, and it is with the 1965 Act that started that, and especially now I see with the 1986 or 87 law that imposes draconian consequences on people who are here for a year without authorization. If they leave, they can't come back for 10 years. That freezes everybody in place, making the pool of unauthorized people greater, and meaning you've got to bring your families with you because you may never see them again because you can't get back home. And so that, it seems to me, is in the realm of unintended consequences, and I wonder how lawmakers and policymakers can avoid, maybe it's impossible, this type of unintended consequence.
I think Jayesh started to take a shot at that
Yeah.
earlier. So.
Sure. Well, I mean, I think you're raising an important point around the narrative that we create around immigration and the presence of immigrants, and they're often associated, there's an assumption that the people who are coming to the United States want to remain here permanently. And that's simply not the case. Before I began teaching, I worked for a number of years working with day laborers and festivals. And the common narrative was, no, I'm not really trying to live here permanently. I just want to be here for a couple of years, make a little bit of money, and then go back and build a really nice house for my family. And I think that in large extent, the immigration laws have really failed, the kind of dichotomous approach, either you're not here at all or you're here forever, has really failed to kind of capture that middle ground. And I think, there was a comment made earlier around globalization, right? And I think what we're seeing more and more is kind of binational existences, kind of dual national identities. And that's another feature that we need to contemplate, right? People, I think, increasingly may want to have kind of a binational existence, right? Where they'll have homes or connections in more than one country. It's certainly playing out with many people, right? Dual citizenship is becoming increasingly common and flexible. So I absolutely do agree that in terms of our policy, it's structured in this very kind of black or white type of way, and we need to think creatively about how we can create these pathways either for kind of binational or temporary, semi-permanent come and go, or as I said earlier, kind of expanding the opportunities for temporary engagement in the U.S.
Other questions?
Hi, I'm Sean O'Neill with the Immigrant Tax Inquiry Group. And one of the things, we need to bring dignity and respect to these people. They're all people. And I think fairness is in there too. But are we being fair to the American taxpayer when we're placing a $10 billion demands on our essential services like healthcare, education, the penal system, fire and police. The taxpayer right now is being treated unfairly, and they should be in the equation.
Well, there have been a series of National Academy of Sciences studies, similar to the ones that I think Jayesh may have mentioned, that suggest that in sum and in total, immigrants more than pay for themselves over the long term. Now, with specific groups and specific services, and particularly at the state and local level, since much of the tax revenue goes to the federal government while localities bear the burden of services. And especially when taking the demographics into account, like younger immigrants, younger poor immigrants, they will tend to consume more in services than they pay in taxes. But the same is actually true of any younger, poorer population, regardless of whether they're immigrants or not. So I don't deny your point that there are larger ramifications from immigration, and that everyone affected, which is everyone, ought to have a seat at the table in discussing how to resolve it. But I would resist the notion that immigrants are a net negative economically or with respect to specific government services.
If I could add to what Charles is saying, Charles had pointed out that it is possible that there might be some effects at the state and local level, and this actually goes to a significant part of the empirical work, empirical research I conducted with my co-author for our book, which was to ask the question, when you look at the restrictionist laws that were emerging at the state and local level over the last 10 to 15 years, thinking about SB 1070, other places that were attempting to deny things like social service on the basis that immigrants were consuming a significant amount. Whether or not it's true that at any given locality or jurisdiction, immigrants actually did consume a significant amount of social services and tax money, what our empirical investigation revealed was that jurisdictions that tend to pass these restrictionist laws actually were not suffering from those social ills that they were arguing about in their law. So while they would write, for example, in the purpose statements of their law that they had suffered significant social service deficits and that immigrants were changing the way in which they were providing those services, as an empirical matter, at least in those jurisdictions that were proposing and passing these laws, as systemically when you look across the United States, it was an unsupportable factual statement. There may have been jurisdictions which that was true, but those were not actually the same jurisdictions that were passing restrictionist legislation. You can look at a jurisdiction like California. California houses close to 3 million unlawfully present persons. That is roughly one-third, roughly a quarter to a third of the total unlawfully present population. Yet California during this time was passing the most integrationist social services laws, including more currently laws directed at the healthcare of undocumented immigrants. So I think there is a fundamental, there very well might be these economic effects. The interesting thing for me is that it doesn't actually show up in the policy proposals at those jurisdictions.
Quick follow-up?
Quick follow-up, and you've referenced the Bracero program a few times, and it seems that that's the model that seemed to have worked best. We could go back to something like that. And a lot of the discussions about civil rights and 7% from this country and 7% from that country. I mean, I've talked to people on the Hill about immigration reform. And if you're on the left, you want everybody to have full citizenship. And if you're on the right, you want to enforce existing laws and deport people. And then there's a bunch of stuff in the middle, too. But we're going to need a broad-based coalition to effect change. We're going to need the left and the right and the middle to come together around something. And it should be very practical and not something that is so burdensome that I'd be interested in your thoughts on that.
another Villazor program, Jayesh?
Sure. No, please. But I mean, I think your general point is very well taken, right? That there has to be some kind of political compromise. Just one quick response to your earlier question is that we need to contemplate the reality that there are a lot of mixed status families in the United States, right? So it's really difficult, even with all the studies then, to disaggregate if immigrants contribute X or they take away X, when in fact many families are comprised of persons who are here lawfully, including citizens, and people who are not. So that muddies the waters. But you know, of course, there's a really clear evidence around significant exploitation under the Villazor program. I'm not going to get into the particulars, but it's certainly not a model. But I think what you're suggesting is the idea of some type of temporary, kind of keep beating the same drum here, right? Temporary visa program that both enables employers to take advantage of foreign-born workers, to avail themselves rather of foreign-born workers, not take advantage of. That was my next point. To not exploit in a non-exploitative way is really something that we need to be thinking carefully about. Because in the existing Villazor program, and then replicated in the H2 program today, the H2A and especially the H2B program, significant incentives for employer or recruiter fraud and misrepresentation and exploitation. Multiple studies have been done on this. So not that every employer is coming at it with ill intention, but structurally it lends itself to that. The 2013 bill had a proposal that said the W visa programs, okay, you know, it was a decent compromise. We can criticize it and pick it apart, but I think as we move forward, that would be, you know, that was a result of a lot of compromise, right? AFL, organized labor, the business community, Chamber of Commerce, ag sector were all at the table, and they came up with that. So it can be done again.
So I'm sorry, we've come to the end of the session. I've got the high sign. Thank you all for participating. I will thank the panelists for their extraordinary contributions, not just at this panel, but through their books. So please look for them. So thank you all for coming.